Well, Alex, thank you so much for coming today and speaking to me about debt remediation. That is very, very crucial to know, especially in this uncertain environment where when anything could happen with the economy. Could you introduce yourself and tell us what you do and what's your expertise? How long have you been doing this?
Yeah, thank you for that invitation. And my name is Alex Hunsen, and currently I run corporate debt mediation department with a law firm specializing with debt eliminations and assets protection, Julie Arsenault, Debt Law. I've been running their mediations department for the last 2 years, and probably the reason why I've earned that position is 7,000 cases which I've done over the last 30 years. By volume, before I retired, I was one of the busiest mediators in Canada, and I worked for various law firms and also for a bankruptcy trustee firm. Igor?
That's perfect, Alex. And why do you think now it's the time when the Canadian businesses and individuals need to know about the debt mediation?
The time was always now in Canada for the last 15 years. We were running everything on debt, and we were sort of faking prosperity by borrowing on all sorts of levels, from personal and corporate. What's alarming right now, and what is the law firms I work for message to the public, is triggered by the prevalence of those bankruptcy trustee ads. It's regrettable to see that Canadian businesses and individuals who are in severe debt are seeking advice from bankruptcy trustees. I understand that the bankruptcy may be on people's mind, nothing wrong with bankruptcy, but going to the trustee himself for advice makes no sense. Number one, bankruptcy trustee cannot by law work on behalf of the debtor. So if you are a debtor and you seek protection from trustee, beware, because by law they represent your enemy, the creditor. They are not lawyers, which means they cannot create confidentiality environment. And if you will ask any trustee whether he can negotiate or strategize on your behalf, the answer is no. They also get paid more. It's called government tariff, when the option they'll suggest to you is more expensive to you, the debtor. Hence the prevalence of those ridiculous consumer proposals, which rarely make any sense, but make a lot of money for trustees. So our main message, or sort of an awareness campaign from our law firm, which is urgent, is to combat the bankruptcy trustees' prevalence on the ads everywhere. Whatever media you turn on, you hear these guys. So number one, debt problems are legal problems, and you should seek law firms' advice of what are your options, and you should never consider the bankruptcy trustee first. So this is why my message to you of why so much urgency these days. Well, Canada was in debt in 15 years. COVID was 5 years ago when we've peaked. So that urgency was always there. But what we're seeing more oftenly is a lot of people who are victims of going to the bankruptcy trustee first. They lose houses, they have liens registered on their properties, they lose investments. That's where the message comes from our law firm, and that's why I'm welcoming you, Igor, in the team of individuals and professionals who are spreading the news that if you've got the legal problem, contact the law firm. Sort of, if you're handcuffed, you don't talk to the police. If you're rear-ended in a car accident, you don't talk to insurance company directly. Same with that.
Oh, perfect. That makes sense, Alex. And can you elaborate on what clients are you dealing with? Are they mostly corporate or mostly individuals or both?
Good question. We consider ourselves an emergency clinic if it comes to debt, a law firm which is specializing in drastic situations. And you'd be surprised that for some janitorial business which has, let's say, $100,000 of debt, the stress is identical to the stress of somebody who owes $10 million to CRA. There are only two stress levels, high and none.
Mhm.
So what we assess are individuals who feel that pressure, who have sleepless nights, and who have all kinds of envelopes or threats from the legal departments from creditors. So if you owe 50, 40,000, we invite you to contact us to let you know what options are out there. If you owe $20 million, let us know as well. We'll treat all these emergencies equally. But what we've noticed, and I remember I spoke to you before this discussion, Igor,
Mhm.
is the trend. The trend right now is construction, is manufacturing, and everything related to cross-border trade, which is everything Canada does. So if you are in construction, regardless whether you are a developer or a drywaller, you are in debt. Not only personal debt, which fueled your business, but also corporate one, suppliers, HST, source deduction. Uh, Find out what are your rights, because we have noticed a lot of large construction companies which have 3 lawyers on staff, and none of them woke up that company to the idea of researching whether they qualify for the debt reduction or
Mhm.
protection. So the trend is that more and more bigger companies are looking for the plan B, because plan A of cutting costs and finding new customers is a mirage these days.
Mhm. Mhm. And you mentioned a few programs before, such as consumer proposal, bankruptcy. So, can you elaborate on those programs? What are the options and how they work?
Sure. You see, when people see the Bankruptcy Act, which is that thick, they're under impression that this is the act which only describes the bankruptcy, and that only bankruptcy trustees are allowed to interpret it for you.
Mhm.
Well, far from the truth. Well, there is only one criminal code, and there are attorneys who defend clients who are reading it differently, and the prosecutors are doing it differently. So
Mhm.
interpretation is what it's all about. And even if you contemplate bankruptcy, if you will go directly to the bankruptcy trustee, it's sort of an equivalent of assets surrender. Yes, he will give you protection, even from CRA, but all assets vest with him for the benefit of creditors. Imagine that most of the work to evaluate the business assets, like receivables or auctioning it off, could be done before bankruptcy, without involvement of bankruptcy trustee. So we know exactly what is the cost of potential bankruptcy before we ask to have that stamp.
Mhm.
So even if you say, well, there is a bankruptcy and my nephew had a bad experience, well, probably because he went to the trustee directly. So the bankruptcy itself is the beautiful option for people who don't have any other choice. And it's very highly regulated, meaning it's very predictable. And you could have your rights if it comes to what assets you want to
Mhm.
involve or not. So I just repeat the same mantra. Find out, even if you contemplate bankruptcy, let us know. We can guide you through the scenario, so we eliminate unknown or unpredictable part which the trustee's involvement is inherent with. The other options designed to give you the same protection from creditors. And what I'm talking about, the government programs, I'm talking about the ones which do not involve negotiations, sweet talking to them,
Mhm.
bribing them, or I don't know, lunching them. There are government programs which guarantee the positive results. Not only that 100% stop any legal actions and noise on the phone, but also protect your bank accounts and allow you to start fresh at the fraction of the debt you owe.
Mhm.
It's all assets driven. If you have $1 million assets in your corporation and $10 million of debt, how difficult do you think negotiations are? They're very easy, because the creditors finally realize that the threat of bankruptcy is bad for them.
Mm-hmm. Mm-hmm.
The bankruptcy hurts the creditors the most because you just walk away from the debt and start fresh.
Mm-hmm.
So the creditors will do everything in their power to persuade you not to go bankrupt.
Mm-hmm. Mm-hmm.
And if the most corporate bankruptcy end up with 10 cents to a dollar, and they will have to wait for years for some outcome out of it, if you have this cards in your hand, they can accept even 20, 25 cents to a dollar, and that involves CRA as well.
Mm-hmm.
So having that Bankruptcy Act interpreted as your defense, as a blessing rather than a curse, gives you strategy to avoid it altogether.
Mm-hmm. 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 Well, uh, that's that's hopefully optimistic, especially for some people who are, in a dire situation, running in debt, both individual and corporate. And speaking of the stress level, I like the way you put it, that there's no stress or high stress. If it's like if people get judgments by mail, they get calls from CRA, CRA freezing their accounts, etc. So is it already too late, or is there still a
Good
chance
question.
for them to
Uh,
fix the situation?
Yeah. So let's start with the first part of your question, stress level. Well, Canadian society is stressed out of their minds. Behind the closed door, there is nothing else but financial stress. I'm talking about the rich people who are millionaires who are chased by multi-million dollars judgments, regular individuals like you and me chased by $100,000 credit cards debt, and the stress doesn't end up with a word, stress. It impacts a family, divorces, suicides, heart attacks, substance abuse, cocaine, fentanyl,
Mm-hmm.
uh, all kinds of alcohol abuse related to trying to cope with this debt. So if you will say, is it too late? Well, stressing us up about it doesn't fix the problem.
Mm-hmm.
You know,
Mm-hmm.
so you can stress the bejesus out of yourself, but the debt doesn't move. Now, most of the debt doesn't sneak up on people either. When CRA slaps the lien on a house, which is usually kiss of death and you can say this house goodbye, but there are multiple warnings. This tsunami wave doesn't appear out of nothing.
Mm-hmm.
So usually when people are stressed out and there are letters, threatenings, judgments, frozen bank accounts and what have you, it is late. But it's never too late until they get paid. So if there is an outstanding balance and you are already ending up with a frozen bank account and they are threatening that HST is going to attack another bank account and your house
Mm-hmm.
may have a lien, well, run to find out what are your options. Stay away from trustee, learn from your lawyer, or call our law firm. We will free of charge determine what is the risk, how to implement protection, and above all, how to save your
Mm-hmm.
assets. Canadians are notoriously badly positioned in fight with the CRA or creditors. They tend to have assets only in a couple of class of assets. One is real estate. Well, it's visible out there. CRA knows you have it. You probably disclosed your banks on applications you have it. So here's that equity, which is very easy for CRA and others to attack because you're stuck with this. You cannot skip town. You cannot put it under your pillow. The second assets are registered assets. That R means
Mm-hmm.
that CRA knows about it.
Mm-hmm.
Okay, it's registered. So plus stocks, bonds, another thing Canadians do, that's why I end up with the sophisticated clients shocked that their bank accounts is frozen by CRA. Well, they have given up privacy for convenience. If you give the CRA rights for electronic transfers, you give them your bank account number, so
Mm-hmm.
don't be surprised that they know where it is.
Right. Mm-hmm.
So a lot of people are coming to us late but it's never too late if you still are in debt which you cannot manage. The most important factor is when you start learning that the debt affects your family, on stress level, divorces, fights, you know, the rest of the story, you've seen it all, then it's time to do something, because even if you will lose money, at least preserve your family's sanity.
And so, if I understand correctly, it is possible to reduce or eliminate the debts on both personal or corporate level and not to lose all the assets?
Correct.
Mm-hmm.
Correct. It is possible because you have your rights in this country. I have seen many individuals who just simply went to the trustee and trustee took them to cleaners as it his job, or they went and seek advice from law firms specializing in assets protection to find legal ways to save these assets. Remember that we all have seen a lot of Hollywood movies, and the trick to transfer the house into wife's name for $1 is nothing else but a trick. It's a Hollywood trick, and I'm not talking about tricks like that,
Right.
or I'm not talking about giving a house to a nephew and then skipping the country. No, I'm talking about the programs which reclassify the asset in the way that CRA has to recognize it as legit. We're not talking about improvising, sacrificing the goat for good luck, and let's try this or that. No, we only specialize in programs which, as you indicated, guarantee the debt reduction and elimination permanently with being able to keep the assets. It depends on the timing. Sometimes it's too late. Sometimes there is plenty of time.
Okay. Okay. So, I guess the best way, as you mentioned several times, is to get in touch with you and see, explore what the options are. For that call, does the client have to be prepared somehow, or what information do they need to uh, prepare in
Good.
order for make this call effective?
Good question. We consider ourselves an emergency department if all things financial. So if you call the ambulance, you don't need to be prepared. You just have to dial the number. And I will not ask for last name or credit card numbers or detailed debt. You know, if you drown, you drown. It doesn't really matter if it's in 50 feet of water or 100 feet of water.
Right.
So ballpark debt is what I will need. Ballpark assets level, ballpark income, and just a story within 5 minutes of unraveling it without having any paperwork in front of the client, I can pretty much determine if we can save a day and reduce the debt or not.
And then how does the process go from there, assuming that
Yeah,
the client
once we
qualifies?
once we determine that we can add value and we can get protection from creditors and reduction of the debt, then we assess how much time we have. Is the creditor really at the gates? Are they already ending up with the judgments? And is the situation urgent? If it's urgent, we act immediately, the same day. We specialize in emergencies. That's where we can add most value, and that's what we gravitate to. So if the person calls us and is very proactive and just asks questions, we will treat them with a full respect, answer the questions, but there will be no emergency or urgency from our side. But most companies who actually are in a position to contemplate the information are in the hot spot, and I can promise that we can address it same minute.
Okay. Okay, so yeah, I think that these are all my questions. I also have questions about the fees, but I don't know
Good
if
question.
we.
Yeah, yeah, ask the
Yeah,
question.
let's record it, but then we'll see what
Mm,
whether we will include it
yeah,
later on.
yeah,
All right, Alexa. So, how would you be able to comment on the fees that the firm charges for this type of mediation services, and
sure.
who's actually paying those fees, whether it's creditor or debtor?
Yeah, good question. So the first question people ask themselves when they are calling a law firm related to their debt is, hey, I'm already in debt, I can't afford anything, now I have a legal cost. So number one, we offer free of charge analysis of what the person qualifies for, and if there are any programs designed to eliminate threat from creditors and reduce the debt. So that's free of charge. We don't ask for any commitment, any decisions, last names. These discussions may take up to an hour if I need to dig deeper, but that's completely free of charge. If it comes to quoting the fee, it has to be affordable. What's the point of me quoting the fee which is not affordable? I'm just another noise asking for a payment. So we make sure it's affordable, and we make sure that the fee structure itself does not delay the actions to save assets and eliminate the debt.
Perfect. Okay. Okay. Well, I think that's all my questions, Alex. If you find this information valid for you, you can book a free confidential corporate debt assessment with us. No documents are needed and no special preparation is needed. You can give us a call at 647-800-5006 or send us an email at ask@fgwinc.ca.